Welcome, everybody. Ready to get our program started tonight. Thanks to everyone who's here in the Andrew Breitbart Freedom Center here at the Heartland Institute. We appreciate you being here. Monday nights isn't our usual night. It is usually Wednesday nights, so it's good to see you all here, that you could fit it into your schedule. And welcome to everybody also watching on YouTube and on Facebook Live. My name is Jim Lakely. I'm the Director of Communications at the Heartland Institute, and I just wanted to tell you a little bit about our organization. We were founded in 1984 in Chicago by a group of individuals led by our founder, David Patton, who met regularly to discuss the value of free markets and individual liberty and the need to promote those ideas to the general public, as well as state legislators and policymakers, but not from Washington, D.C., where there's, let's just say the market's saturated for that sort of thing, in the swamp. But to do that out here in the heartland, in the Midwest, in the heartland of America, thus our name, the Heartland Institute. We are a think tank. Our business is ideas, and our mission is to discover, develop, and promote free market solutions to social and economic problems. For instance, we spent a day laying out the free market solutions to the so-called climate crisis and an energy policy at our America First Energy Conference on November 9th in Houston, Texas. The solution for cleaning up our environment, not of carbon dioxide emissions, because that's not actually pollution, but the free market solution is to make affordable, or to make energy more affordable. And in that respect, it's to make more use of the fossil fuel wealth underneath our feet. It was a fantastic conference, and I encourage you all here and watching online to go to americafirstenergy.org to see all of the footage. We are almost complete putting all, I think, 35 of the separate presentations as their own little videos, so you can browse around and look at just what you wanted to look at, or you can watch the entire thing from start to finish. It was a fantastic conference, very, very successful, got media coverage in the New York Times and the Washington Post, CNBC, and so please do check that out. And if you like what you see tonight here in the building and also watching online, I encourage you to look around at heartland.org. You can check out our blog, The Freedom Pub. You can check out our daily podcast on iTunes. We're on pace for 2 million downloads in this calendar year. So we're very proud of that. And I think that's because as a think tank, again, we're in the ideas business. We have experts from inside the organization that are talking about public policy in a very compelling way. You're going to learn a lot from the Heartland Daily Podcast, so I very much encourage you to check it out. It's easy to find. Just put Heartland Daily Podcast in a search on iTunes, or you can check us out also on SoundCloud or at the podcast link at heartland.org. You can also check out our YouTube page. As I mentioned, we're going to have all the videos from our energy conference earlier this month there, and that's Heartland Tube on YouTube. And of course, that's where we're live streaming this event here tonight, and all of the events that we've had are in its own playlist at our YouTube page, so you can check out anything that you may have missed. And if advancing these free market principles and free markets and liberty is important to you, I hope you'll consider joining the Heartland Institute by becoming a donor and a supporter of us. There are boxes on your tables where you can get more information about Heartland and donate tonight to help keep the lights on and keep these events going. You can also volunteer for the Heartland Institute. We have some volunteers here tonight. We have volunteers at all of our events. We have volunteers that are in here every single day because they believe in advancing free markets and liberty, and they want to do something outside of a financial contribution to help that mission. And so please consider doing that as well. It doesn't have to be a large commitment, but you'll feel good knowing that you're fighting for liberty alongside everybody in this building. With that, I was going to introduce our speaker tonight, but we're very happy to have somebody who's a much better speaker than I am. Joe Morris, a renowned attorney and leader, really, of the conservative, I think, leader of the conservative legal community in the Chicagoland area. It is my honor to introduce him, to introduce our speaker tonight. Please welcome Joe Morris.
Thank you, Jim. Well, that was very generous. Thank you. It's a delight to be with you at Heartland and to be with Jim Lakely, Heartland's outgoing president, Joe Bass, and incoming president, Tim Huelskamp. And to be with all of you. This is just a fabulous evening. If all you knew about judicial selection and the education of lawyers is what you learned from the pages of the New York Times, I pity you. But unfortunately, there are a lot of people whose learning is limited by what they see in the Gray Lady of Times Square. And so there's shock that President Donald Trump, stop there, shock that there's President Donald Trump, but there's shock that President Donald Trump is successfully appointing lawyers to the federal judiciary in record numbers. Shock that there are record numbers of vacancies, and that he's able to find conservative lawyers, shock, to fill those vacancies. Where is the conspiracy here? That Trump was elected, that there are all these vacancies backed up, and that there are somehow qualified conservative lawyers to fill them. Well, I don't have a brief tonight to speak about the shocking election of Donald Trump, although tonight's guest speaker shocked the academic community of which he is a distinguished member by openly, publicly endorsing the election of Donald Trump, signing on to a number of national statements of professors for Trump. And it's not my brief to discuss the architecture of the federal judiciary and its backlog of unfilled seats, but I do have something to say about the source of this legal talent. It is not an accident that there is today in 2017 a remarkable number of highly qualified, highly credentialed lawyers who qualify as we say in the jargon of the trade, originalists or textualists. It is, in fact, the result of a generation of hard work undertaken by teachers and thinkers of the law to educate young people in this sense of what law reading, law judging, the business of judgecraft is about. And one of those educators is here tonight to speak to us about the Legal Academy. It's not been a conspiracy. It's something that's taken place out in the open, out in public, criticized every single day, the development of this jurisprudence of originalism or of textualism. Edwin Meese, Attorney General, 35 years ago, called it the jurisprudence of originalism. Justice Nino Scalia, another great thinker and advancer of these legal philosophies, preferred to call them textualism, but the idea was the same. The idea was that that a just government ought to be a government of laws and not of men, as the phrase goes. What does it mean to be a government of laws? It means to anchor, to restrict, to limit the discretion of judges, their ability to impose their own will, their own preferences on situations by something external to themselves. What is that something? The best thing that human ingenuity has devised are the texts outside themselves, external themselves, that others have created to make the law, whether it's the sovereign people making a constitution or the people's representatives in a legislature making statutes or ordinances, or it's people making private law as they write their contracts or write their wills or write their leases and so forth. They are creating texts. And what is the effect of texts? The effect of text is to impose limits on the extent to which judges, when called upon to adjudicate the disputes that arise in those relations that are governed by those texts, so that they're not imposing their own preferences, their own thoughts as to what really ought to happen in the way you run your business or the way you live your life. Instead, they are guided by choices of value, a hierarchy of value and preferences that someone external to themselves have made. To this room, I don't think these ideas sound shocking at all. They sound like something that ought to inhere in a notion of the rule of law. 'Tis not always thus. A century ago, there arose in America and elsewhere in the West the generation of the legal realists, people like Oliver Wendell Holmes of the United States Supreme Court. The game was given away by a Republican politician, interestingly. Charles Evans Hughes, one-time governor of New York, once Secretary of State, once Chief Justice of the United States, who in a speech to a Chamber of Commerce in New York, downstate New York, or upstate New York, I guess is the way they say it in New York. It's downstate in Illinois, it's upstate in New York. Once said in a speech to a Chamber of Commerce, the Constitution is a great thing. It's the bulwark of our liberties. What is the Constitution? It is what the judges say it is. If the law is what the judges say it is and not what somebody else says it is, then we have a government of men and not of laws. And we've been working assiduously for 100 years to get out from under the burden of the overthrow of the rule of law, the overthrow of the doctrine that the government ought to be a government of laws and not of men, to get back to what seems to us to be commonsensical, the Mies doctrine of originalism, the Scalia doctrine of textualism, to put a shorthand on it. The man we're about to hear from is somebody who's been working assiduously in the Vineyard for the last generation or more to teach people about the rule of law. Steve Presser teaches law at Northwestern Law School here in Chicago. He's a practical guy. He also teaches business students over in the Kellogg School. He's extremely well educated. He was thoroughly exposed to the doctrines of the legal realists and the critical legal thinkers and others. He went to a very well-known college and law school at that institution known as the University of Chicago of the East. I'm referring, of course, to Harvard College and Harvard Law School. And he has devoted his life to teaching people. He is the Mr. Chips, in a sense, of the Northwestern University faculty, by which I mean he is not only known as somebody with a rigorous mind, but an awfully kind personality. A teacher in whom students can confide, a teacher who bends over backwards, who goes the extra mile to assist students in understanding concepts that are often difficult at first blush. He exposes himself to criticism, to debate every day in the classroom and has for a generation. He also does it in legal writing, in the learned journals, in the professional journals, and in books. And he has made it part of his study to study the intellectual history of the law. What is it that law professors, who after all are among the most important transmitters of legal doctrine, perhaps not as important as judges in terms of developing legal doctrine, but certainly on the immediate firing line of transmitting legal doctrine and legal education to the people who are going to be the lawyers and judges of the future. Steve has done that work both with brilliance and rigorous thought on the one hand, and a kindness and an ability to guide students in learning and developing a love of learning and of critical thought on their own throughout that process, all the while doing it bravely. It is therefore with great pleasure on behalf of the Heartland Institute that I welcome to this lectern for a discussion of the Legal Academy, what law professors know and do not know, Professor Stephen B. Presser.
Thank you, Joe, for that really fabulous introduction. You may have guessed, Joe already gave my talk for me. And it's a little bit of a tough act to follow, but I'll still do my best under the circumstances. It's an absolute treat to be here. Let's see, I think that ought to do it, in your new quarters, and to be able to address you with this wonderful PowerPoint. The presentation is called, "Do Law Professors Really Understand American Law?" And the answer is, well, no. And I'm going to try to explain why that is. Now, you all have an image, what American law professors forgot and what Trump may have known. Law professors. What are they like? Well, there's our image. That comes from The Paper Chase, still an absolutely fabulous movie, and I'll bring that slide back in just a minute. I want to give you a roadmap of what it is that I have to say. Joe has built up your expectations. Lower them a little bit. All I want to try to do is get through the next 30, 40 minutes without permanent tissue damage on either side. What I want to begin by is to give you a little bit of a roadmap. I teach at Kellogg, that's the business school, and the Kellogg students always want to know, what are the takeaways? What are the takeaways? Curiously, law students have never asked for that. But management school students do, and I want to give them to you. I'm going to make some remarks about a divided nation and a division on the law that seems to be inherent in that division. I'll make a few remarks about the president and his model justice recently put on the court. I'm going to talk about the way things were. Joe alluded to that. And Then I'm going to explain how things changed, and Joe identified the villain. It's Oliver Wendell Holmes, Jr. I'm not sure you knew he was the arch villain, but I'll explain why in a little bit. And then I'm going to suggest how, and Joe hinted at this as well, after Holmes, things just kept getting worse. And I'm going to talk about exactly how. Essentially what happened was the growth of the view that the law is malleable according to politics. Indeed, in the words of the critical legal studies folks, law is politics, pure and simple. I'll talk about that a little bit. But then I'm going to suggest, and Joe did this too, he really did my talk, that there's something better than that traditional view, and indeed there are signs that we're moving back to that. All right, first thing I have to say is, you may have figured this out, I'm going to take us back to the past to shape the future, and I'm going to do it by referring to this book, okay? I'm not sure how well you can see it. Law Professors, 3 Centuries of Shaping American Law by me. It was released last December, got a nice review in The Economist and a few others. It makes an absolutely superb Christmas, birthday, wedding, or bar mitzvah present. It's available on Amazon.com and from the publisher. And if you're tempted after the talk, you might want to take a peek. All right, now, the first thing that got me going and got me writing the book was a deep division in the nation. All right, showed up, I think, most clearly in the last election when Mr. Trump defeated Mrs. Clinton. You've seen, I'm sure, this map. That's the blue state, red state by states. And you'll notice the coastal states, to a great extent, except for those in the South, went to Mrs. Clinton, with a few places in the heartland. The rest went to Mr. Trump. Maybe you've seen the county map, which is even more dramatic. What could be going on there? Well, I don't think it's because people all across the nation were reading the Supreme Court opinions of Anthony Kennedy and Sandra Day O'Connor and saying, this must stop. But there does seem to be some surveys who said that at least 60% of people made their vote based in part on the kind of appointments that would be made to the court. So people were thinking about this issue. There's a deep divide, and what I'm going to argue, and I'm convinced of this, is that there's a deep divide in jurisprudential views between the two parties. The Republicans see things one way, the Democrats see things another. It didn't used to be like that, at least with regard to selection of judges. Until Bork, as you know, there was a fairly broad agreement that if somebody is qualified, you confirm them. No longer. Now things depend on what Chuck Schumer calls judicial ideology. I think that's an oxymoron, judicial ideology, but he believes in it. So let's talk about it. Why was Trump the pick of so many people, at least geographically dispersed? I think part of it had to do with his view on justices and jurisprudence. And this is not generally understood by the media. You know the usual view of Trump. It's as of a lucky buffoon who somehow ends up in the Oval Office. I think he's more than that. I guess it doesn't take too much to be more than that, but he is. He's actually thought, at least if you take his speeches as an indication, about what judges ought to be doing. Now, when you asked him, who's his model justice? It's that man, Antonin Scalia, his model justice. He further, and maybe you know this, he further got a list of potential justices and indeed lower court appointments as well from the Federalist Society and from the Heritage Foundation. That's pretty thoughtful, okay? He did pick one. There he is, Neil Gorsuch, a Kennedy clerk, but nevertheless a very reasonable person and a very, I think, good justice. To use the words that Joe used very nicely, Scalia and Gorsuch are textualists, or if you like, I think for these constitutional purposes, it means the same thing, adherence to the original understanding. But again, as Joe pointed out, this perspective is way, way out of favor these days. So one of the things I sought to do in the book was to figure out, why is that? Why is this notion of a government of laws, not of men, laughed at in the academy? How did this come to be? All right? There was a second thing that I wanted to explore, and that was the popular conception about law professors. The person who brought this to a head, really, is that man. That's Leon Panetta, longtime member of Congress, former White House Chief of Staff, former CIA Director, and former Secretary of Defense. Early in the Obama administration, he said of Mr. Obama that, quote, his most conspicuous weakness was a frustrating reticence to engage his opponents and rally support for his cause. Elaborating, Secretary Panetta explained, that is not a failing of ideas or of intellect, but still, Mr. Obama does, however, sometimes lack fire. Then came Panetta's most cutting and much quoted observation. Too often, in my view, said Secretary Panetta, the president relies on the logic of a law professor rather than the passion of a leader. And he was a law professor at Chicago for a long time, but I wondered, wait a minute, what's wrong with the logic of a law professor? Clearly, the implication is it's illogical. What can that mean? How can that be? What was Panetta trying to get at? Was Panetta right? Consider the words of Duncan Kennedy. Oops, going a little out of direction here. I'm sorry. Oh dear, oh dear. We're experiencing a technical failure here. Let's go back. There we go. All right. I think I know what I'm doing now. There's Kennedy. Kennedy taught at Harvard for a long time, major figure in critical legal studies. I'll tell you about them in a little bit. Here's what Kennedy said about teaching law. And ask yourselves, those of you who are lawyers, whether this sounds familiar. One of the first and most lasting impressions that many students have of the law school is that the teachers are either astoundingly intellectually self-confident or just plain smug. Many of them seem to their students to be preening themselves before their classes. In most cases, each gesture seems to say, I am brilliant. I am famous in the only community that matters. I am doing the most difficult and most desirable thing in the world and doing it well. I am being a law professor. Well, it's true. I've lived my life that way for the last 40 years. And maybe that's the stock image that we have, Kingsfield there, from the paper chase. But maybe there's a problem. Here's one more man who addressed that problem. The Chief Justice of the United States, John Roberts, a graduate of the Harvard Law School, like all his brethren on this court, graduate of an elite law school, Harvard or Yale, I think with the possible exception of Ginsburg, who spent a year or two at Columbia. He declared, the Chief Justice did, that the sort of things law professors now publish in the law reviews is of limited to no value for those actually dealing with the law. Listen to this. Pick up a copy of any law review that you see, and the first article is likely to be, the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria, or something, which I'm sure, said the Chief Justice, was of great interest to the academic who wrote it, but isn't of much help to the bar. The Chief Justice remark prompted a tongue-in-cheek study of the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria by Oren S. Kerr, a professor at the George Washington Law School. I'm happy to report he quite properly concluded there was no such influence. But the Chief Justice had it right. A lot of the things that law professors write, indeed maybe almost all the things that law professors write, are of limited to no interest to practitioners, or even, if you listen to Richard Posner, and I think he's right about this, on judges. They're thinking about stuff that judges and lawyers don't, the law professors are. Now, why is that? What happened? Well, I want to go back with you, and I want to explore the way things once were. The view of the law that Joe talked about as the earlier view. It comes really from Blackstone and from our heritage in the common law. In Blackstone's commentaries, which, by the way, are still quite interesting reading, and you'll notice the private law that he talks about is very similar to what he describes. He said in his book that, he said, he didn't say it exactly that way, but that was the thrust of it, if we had law without equity, it would be a lot better than equity without law. Because with equity, judges decide basically on what they like, the chancellor's foot, in other words. If you have law without equity, at least it's certain. And that's what the law ought to be. Judges shouldn't make law. He made that clear. That was the basic understanding. There's a difference between judging and legislating. If you look in the Federalist 78, quoting Montesquieu, the idea that if judges make law, it's tyranny is very clear. That's the way it used to be. That's James Wilson. James Wilson was the first American law professor. He taught at Penn. He gave law lectures, which were much like Blackstone's commentaries in the early years of our republic. He was a firm believer in the common law, and he was a firm believer, by the way, that the common law, as was Blackstone, was divinely inspired. The common law rules, timeless rules, that have been around since time out of mind, reflect divine inspiration. That's what he said. That view predominated for a long time, picked up, I think, most eloquently by Joseph Story, who taught at Harvard, who was also a Supreme Court justice, and you may not know this, at the same time that he taught at Harvard, had a chair there, was a Supreme Court justice. He was also the president of the Merchants Bank of Salem and the vice president of the Salem Savings Bank. And nobody saw a conflict of interest in those roles. How interesting. I think the reason for that was probably that the law was thought to be something neutral that he could administer in spite of what we would regard as glaring conflict of interest, not back then. One other thing I want to say about Story is that he firmly believed, as did Blackstone, as did Wilson, that there was an underpinning to the law, even the Constitution, of religion, that you couldn't really have order without law, you couldn't have law without morality, and you couldn't have morality without religion. That was clear to Story, to Wilson, and to Blackstone. But then, things changed. All right? There's the villain. This is where you hiss. Before we go further, take a look at that man. Now, I'll tell you a little bit more about him and what he looks like in a minute. You all know the famous things that he said. Basically, in the common law, his famous 1880 volume, he said, "The life of the law is not logic, it's experience. The substance of the law at any given time pretty nearly corresponds with what is then regarded as convenient. Convenience, practicality. These are the things," said Holmes, "the secret root from which the law is drawn." And Holmes made it clear, by the way, his very profound belief that judges ought to wake up and realize that the law changes, it's always changed, and that they have the power to change it in a practical direction. It's no coincidence that Holmes is Richard Posner's hero, because that's the way that Posner feels about the law, too. You just do the practical thing, he says, and then you figure out a rationale to support it. More about that idea in a moment. Now, those seem like pretty awful ideas for somebody promoting law. Anybody who's read Blackstone would be horrified by that kind of a statement. How did that kind of view, that iconoclastic view, that what later was to be called legal realism view, as Joe pointed out, how did that come to be accepted? Why is Holmes virtually universally regarded as the great sage of American law? You can't give a talk about the law, by the way, without quoting Holmes once, twice, maybe even 3 times. Why is that? Now, look at him. I think there's a clue. Who does he look like? Now, I could ask you, and probably somebody would say, well, my goodness, he looks like Mark Twain. Or somebody might say, no, he looks like Colonel Sanders. Bismarck. Looks like Bismarck. But you know who he really looks like? I'll tell you who he looks like. He looks like God. And when you look like God, you can get away with a lot of jurisprudential shenanigans. His view, Holmes's view, is that you shouldn't think about values when you're doing the law. Brilliant University of Chicago professor, Joe probably knows this, Albert Alschuler, wrote a book on Holmes called Law Without Values, in which basically he explained that Holmes was completely ghoulish, awful person. He's got a chapter that says, would you want Oliver Wendell Holmes as a friend? And the answer is no. Now, why is that? Again, I think it's that view of the law as malleable. I can go just a bit further with that. Another thing Holmes is famous for is the bad man theory of the law. Think about the law, he said, the way a bad man would. What he's interested in, the bad man, is what the courts will do in fact. He doesn't give a fig for your theories, your noble maxims and whatnot of the law. What will the courts do? Again, as Joe anticipated, what will the courts do? That's all I care about. Well, really what was going on here, among other things, was an attack on this man. That's Christopher Columbus Langdell, the great dean who really made the modern Harvard Law School what it is today. He invented the case book, the case method, the Socratic method. By the way, when he first introduced it, his students fled in droves to Boston University, which then got established. But eventually, it caught on. Langdell wrote about the law as if it actually contained logic, and Holmes didn't like that. He said, Langdell is the greatest living legal theologian, and that wasn't praise he was engaged in. Now, I think Holmes got it wrong, but as Joe pointed out, what came next was even worse, okay? Roscoe Pound first. Pound taught for a year at Northwestern. He was the dean of Nebraska before that. Then he was picked up after a year, poached, I guess I'd say, from us by the University of Chicago. And 2 years after that, he went to Harvard, where he became the greatest Harvard Law School dean. By the way, virtually everybody whose picture I'm showing you is a chapter in the book. Much like Holmes, Pound said he was interested not in the law in the books, but in the law in action. He wanted to have something he called a sociological theory of law. Okay, maybe that was the first move toward the arts and sciences. When he was dean at Harvard, he spent a lot of time, Pound did, with the great sociologist Talcott Parsons, with an anthropologist, and with a psychologist. He began to turn thinking about the law in other directions. This man is Carl Llewellyn, famous teacher at Chicago, I think, for a long time. He's probably known as the leading legal realist, and he gets credit in a book called The Bramble Bush, still a wonderful book to read. He gets credit for suggesting, again, as Joe kind of hinted, that what judges do is to come up with the result they desire and then think up a rationale to support it. Now, I think that's anathema, really. And if that isn't bad enough, this man is much worse. That's Jerome Frank. You probably don't recognize him from his picture. He wrote a book called Law and the Modern Mind, and it's really applied Freudian psychology. This desire for a certain law, said Jerome Frank, is like a little child's desire for an omnipotent father. We should grow up, he said, and realize the law is malleable. We should look to the man he called the only adult jurist, Oliver Wendell Holmes, Jr. I kind of like that phrase, adult jurist. Sounds like something you get with a paper bag under the counter, an adult jurist. Be that as it may, Frank's Law and the Modern Mind book, in which he blasted the notion that judging could be objective, had probably the most impact of any book published in the first half of the 20th century on law. Perhaps the most important impact that book and legal realism, which got going strongly in the 1930s, had was on this man, okay? Franklin Roosevelt. Now, you may remember that the Supreme Court, throughout the early New Deal, the National Industrial Recovery Act, in particular in the famous Schechter poultry case, this goes too far. Congress can't legislate in a matter that's purely local. Its interstate commerce power is restrained. So the court threw out that act, basically gutting the first New Deal. The president was not happy, was not happy at all. He said, you know what this court is doing? They are engaging in a horse and buggy definition of interstate commerce. Now that meant that Roosevelt believed the Constitution should change with the times. To use this phrase for the first time in the talk, he believed in a living Constitution. We've got to save the Constitution from the court and the court from itself, he said. Now, he came up with a court packing plan that he never actually got to use, but I think he scared the living daylights out of the court, and in 1936, the court profoundly changed its view of interstate commerce. You're all familiar, perhaps, with the Jones and Laughlin case, where the court, for the first time, essentially threw out that narrow interstate commerce definition and said, well, if there's an effect on interstate commerce, it's okay to regulate it. A lot of cases then followed that line of thinking. But this profound demonstration and the court's undercutting, I won't go into the technical details of this, the old Lochner-era doctrines of freedom of contract, also in 1936, were a clearly profound change. One changed, I think, by the philosophy of legal realism, which certainly had a lot of time as an academic philosophy. And further from the original understanding was, as you well know, this man, Earl Warren, usually regarded as the second greatest Chief Justice after John Marshall himself. You know what the Warren Court did, I hope, in race matters in Brown versus Board of Education, in criminal law matters, Miranda, Escobedo, in redistricting matters in Baker versus Carr, in Reynolds versus Sims. And for those of you who are not lawyers, what they did in short was rewrite the distribution of power in the United States between the federal courts and the state governments. Earl Warren basically declared in criminal law, in race relations, in education, we, the Supreme Court, are going to tell you, the people, how you need to do it. That was revolutionary. People don't talk about that much anymore. But there was a real reason, and it wasn't simply prejudice, that people had impeach Earl Warren bumper stickers on their cars for a long time, and there were those in Congress who actually toyed with it. This was profound change of the law. This was Raoul Berger, the man who gave my chair to the law school. Gave it, by the way, in his own name, the Raoul Berger Professorship. He was not a shrinking violet, Raoul Berger. He made clear that the original understanding of the 14th Amendment that the Supreme Court relied on then and since to alter what the states could do to restrain them by the Bill of Rights had a much, much narrower focus originally. Essentially, it was passed to allow the freed slaves basic property and contract rights and not much more, Raoul Berger said, and I think he was right. Well, I could go into more detail, but I think you get the idea. The Warren Court did something truly revolutionary, a constitutional revolution. Now, maybe it was justified. Maybe the civil rights decisions were desperately needed, although it's not completely clear that change couldn't have happened in other ways. After Earl Warren, the name of the game in the academy became defending the Warren Court. That man, Ronald Dworkin, who taught at NYU and Oxford, decided, well, you know, what the Warren Court was doing was basically just applying principles that were inherent in the Constitution. But once you leave the text, once you start looking for principles, you're giving a lot of discretion. Indeed, perhaps you're allowing arbitrary action on the part of the courts. Principles, not rules. His mantle, Dworkin's, was picked up especially by folks from Yale. That's Bruce Ackerman and Akhil Amar. They spawned a theory known these days as popular constitutionalism. And the burden of popular constitutionalism is the Constitution will change when the people sense a need for a change. They can express that by voting in elections. They can do it by public movements. They can do it in lots of other things. But what isn't required under this theory is that they follow the Article 5 amendatory process. What that really means is the judges can decide that the people have changed the Constitution, and the theory was that's what the Warren Court was doing. To put it slightly differently, this is the theory of the Constitution as a living and breathing document. A living and breathing document. Scalia used to ask, have you ever seen a living document? There's only one kind of Constitution, he said, and it's dead, 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 which was his way of talking about textualism and original understanding. But I'm not done. I'm not done suggesting the horrors in the academy. Upping the ante still further. Here's Mark Tushnet, Morton Horwitz, Roberto Unger, Robert Gordon, Peter Gable. I don't know if you've ever watched, by the way, What's My Line or To Tell the Truth. Arlene Francis is a panelist. That's her son, Peter Gable, one of the major figures in critical legal studies, and Duncan Kennedy. All of these fascinating people. Mark Tushnet once said, if I were a judge, I would do whatever it took to advance socialism in this country, and I would justify what I did by whatever grand jurisprudential theory was then popular. He let the cat out of the bag, did Mark Tushnet. Morton Horwitz wrote a book called The Transformation of American Law, suggesting that the interests of capitalists transformed law in the 19th century, and perhaps suggesting, like Marx, that maybe there ought to be a next stage that comes closer to justice. Roberto Unger is Brazilian. His native language is Portuguese, and I'm told that he's a truly fabulous Portuguese poet. He's also a very active politician in Brazil. He wrote another book on critical legal studies in which he actually made a move sort of back to Blackstone. He said, really, the law shows us that man is divine. Indeed, he said, there's no real difference between public and private, between reason and desire, and man and God. That's pretty strong stuff. He ended his book, Roberto Unger did, on this extraordinary set of legal ideas, suggesting that we mere humans couldn't really understand until there was more divine revelation. So the last words in his book, Knowledge and Politics, were, speak, God. A Yale law professor then wrote a review that said, hello, Roberto, and more or less demolished what he had to say. Gordon, very eloquent theorist for critical legal studies at Yale, and a former newspaper reporter, interestingly enough. Peter Gable wrote a blistering review of Dworkin's book in which basically he called him a tool of late capitalism or pluralism, and Duncan Kennedy I've already alluded to. He deconstructed all of law school and suggested that what we need is to scrap a lot of this stuff and come up with a more just system. These are, now I don't mean to denigrate them, and the chapter on critical legal studies is a little bit sympathetic, but essentially these are tenured radicals. These are folks who really believe the system needs basic alteration, and there's more. Catherine McKinnon, you may know her name. She's a leading feminist. She says, and I'm going to simplify to the point almost of trivialization what she says. It's very eloquent. She says, women have been dominated by men for too long. We need to alter the legal system in a way that ends that domination once and for all. Patricia Williams and Cass Sunstein, two other figures. Patricia Williams, a figure in critical race theory, says we need to retool the law in order to equalize the races in ways that have never been contemplated before. And Cass Sunstein, very influential on Barack Obama, the author with Richard Thaler, a recent Nobel Prize winner, of a book called Nudge, maintains people don't really know what they want. They are not, as Posner says, rational wealth maximizers. They are blinded by their limited intelligence. The government ought to nudge them in the right direction. All right? That's what's out there. These are dominant theories, but don't despair. A possible rearguard action is being fought. As early as 1954, Herbert Wexler said, there's a difference between legislation and judging. I think the Warren Court got it wrong. They failed to follow neutral principles. Paul Carrington, the dean at Duke, who criticized to extreme distress in the academy critical legal studies. These people don't believe in the law, he said. They are legal nihilists. Maybe there's a place for them somewhere in the university, but not law schools. They ought to go to political science departments or maybe religion departments, but not in the law school. And of course, Scalia, who to the very end maintained the ideals really of a Blackstone, the originalist and textualist ideas. Here's another chapter subject, not as well known as these others. That's Marianne Glendon. She teaches at Harvard. She is a rarity in the academy, a conservative woman. Almost none of them, okay? She's also, Marianne Glendon, active in Catholic affairs and was the ambassador to the Holy See for us, still sits on the Vatican Bank Committee, spends a lot of time in Rome. She wrote some devastating critiques of our rights-oriented jurisprudence, and one of her books is analyzed in the law professor's book. And of course, not only are these four brave people at it, but there's me too. Not quite done yet. One more point to make. I suggested that we were going back to the past to shape the future. We're beginning to return in some quarters, especially the Federalist Society, to the view that Hamilton, who in the Federalist 78 did express the notion that judges shouldn't make law. Samuel Chase, my hero, who I've written a couple of books about, joined Hamilton in that phrase that I indicated a little bit earlier. You can't have order without law, you can't have law without morality, and you can't have morality without religion. Now, intriguingly enough, these early folks' arguments were picked up by a non-lawyer, Russell Kirk. And if you read his conservative mind, you get the theories that I think the Federalist Society and quite possibly the Academy are beginning to return to, or at least I hope so. And that's all I have to say.
All right, wonderful. I still think you should wait. You should put your picture at the end. That way, there's lots and lots of applause.
Yeah, sorry about that.
So you can work on tweaking that. If you have a question, we have plenty of time for Q&A here today. Please put your hand up. A microphone will come to you. And if you would identify yourself so that Stephen Presser knows to whom he is speaking, that would be ideal. And I'll be grabbing my phone to read any questions that are made available on either the YouTube feed or on Facebook Live. So we will start right here.
Carl Lambrecht, and you referred to Obama as a teacher, as a professor.
Yes.
I had been told that he was a teacher, a good one, but not a professor.
Well, technically, he was a senior lecturer. He was not on the tenure track. And in fact, his position is the same one that for many years Richard Posner and Frank Easterbrook held at Chicago. Now, he was never on the tenure track. From what I can understand, he didn't go to faculty meetings. He didn't hang around there very much. He was a wildly popular teacher, though. He taught courses in constitutional law, race relations, and voting rights. He really was a professor, but he wasn't on the tenure track. You're right.
Okay. Mike Patton. My question is about the prospects or how influential the rebound from critical legal studies has been. I was talking to someone recently who's very optimistic, saying that, well, if you look at the landscape of legislative construction these days, it's not at all, the old games that we had, and that there really has been a lot of progress made in reining in the courts. Do you think that's true, or that there's really not much been done?
No, I think the movement is in a salutary direction, and I think I echo what Joe said on that. The influence of the Federalist Society has been breathtaking, really. I mean, for the last 15 years, it's been the most popular student organization. It's committed, the Federalist Society is, to the separation of powers and, as the name indicates, to federalism. Trump's judges pretty much firm Federalists. We're starting to see a shift. But Obama did a pretty good job stacking the courts while he was in office, and it'll be a while before, let's call it the nefarious jurisprudence, is completely eradicated. On the other hand, the Supreme Court has obviously an outside influence. If Mr. Trump gets 2 more appointments, the game is over for the next generation or 2, in our favor.
We're going to go right here.
Hi, I'm Jan Bracco. I've taught law at various places. Just for for enlightenment of everybody, I'd like you to take on the idea of the concept of substantive due process.
There's another oxymoron. Substantive due process is the concept that the court invoked, among other places, in Roe versus Wade. Earlier, it was invoked in what I refer to as the Lochner era jurisprudence. The notion is that while procedure, due process, is generally about the way courts function, there still is some substance that no legislature should touch. It's an old idea of super-constitutional principles. In Lochner, it was freedom of contract that the court said couldn't be regulated, so bakers couldn't have their hours limited. In Griswold, substantive due process was you can't prevent married adults from having contraception, and in the notorious Roe versus Wade, as you know, it was somehow due process guarantees that a woman should be entitled to seek an abortion without fear of the law before fetal viability. It's just suggesting there are some areas that governments can't be touched. It is nefarious and made up, I think.
I was hoping you would say it's an oxymoron.
Yeah, it is an oxymoron. The law is replete with them, but that's one.
We're going to go here and raise your hand if you'd like to be next.
Hi, my name is Mike Domzalski. I am not an attorney. I have a few friends that are, and one of the things that has always fascinated me was this concept of jury nullification, which I think was penned by Alexander Hamilton in the Federalist Papers. And I've asked my attorney friends about it, and they've all said, oh, no, you've got to pay attention to the judge. That is not allowed. So I'd like you to expound on that and
I'd be
give a
happy
clarification on that.
To set one thing straight, no, Hamilton says nothing about jury nullification in the Federalist. I think he talks about the jury once or twice, but I don't believe he addresses that. The concept comes, though, from Anglo-American common law. And there was a lot of jury nullification that went on in the early Republican era, and beyond that, really right up into our own time. The way it's shaken down is if the jury acquits a criminal, even if it's very clear that the law was violated, the Fifth Amendment's double jeopardy clause prevents a retrial. Now, in the early days of the common law, it wasn't that way. If the jury got it wrong, perhaps the defendant still went free, but the jury lost all their property, had their trees pulled up by the roots, and all kinds of other their children were unable to inherit, I think on to 2 generations. It was treated pretty seriously back then. Now we don't punish the jurors at all. Now, in the Vietnam War era, a number of draft card burners got their lawyers to request that the judge instruct the juries that they had the power to nullify the law and acquit the defendants. The judges refused to do that. So now we're in the very interesting and anomalous situation where a jury can exercise jury nullification, but they can't be told they can do it. And that's the law as I understand it. Quite extraordinary.
We have a question right here.
I'm not a lawyer either. I'm a recovering economist. But
Were you still able to understand a little of the talk, I hope?
yes, I see parallels between what you're describing happened to the law and what has happened to economics. I mean, the law, as you described it, started out being with Blackstone. The same year he published his work came The Wealth of Nations
That's exactly
by Adam
right.
Smith.
1776.
And since that time, the emergence of common law as an important principle paralleled market economics. Since then, though, the economics profession has gone over the deep end by adopting calculus in almost every academic paper. Now, consider yourself spared from that curse. So there's more hope for the law, I think, than for economics.
That's fascinating. I should say, by the way, as well, Cass Sunstein and Richard Thaler work from something they call behavioral economics, which I suppose is another way of ruining the profession, integrating psychology into it. Worse even than calculus.
My economics professor from a very long time ago said that the theory of behavior in economics has to be logical. It doesn't depend upon the actors being logical, because actors, whether by intent or by accident, choose the right path, survive, and continue to make a difference in the allocation of resources. The ones that make the wrong decisions by accident or by intent lose their wealth and cease to have an impact on the allocation of resources. So it's a similar thought.
Very good.
Right over here.
Thank you. Let me follow up on Jim Johnson's question. Jim and I were privileged to know and be students of Milton Friedman, who once famously said, speaking of his profession, the economists, "Oh, it's all well and good that works in fact, but the question is, does it work in theory?" Let me turn to precisely the question of law and economics, the discipline framed and named in the 20th century and often associated with Richard Posner, among others. Is that it's something that's sometimes portrayed as a market-friendly or even conservative form of jurisprudence? Is it not also, in fact, subversive of what we might call originalism?
I think it is, yes. I mean, for a number of different reasons. If it's practiced the way Richard Posner practiced it, the rule of law isn't very important at all. It's about practical solutions, and the law isn't necessarily always practical. Further, efficiency isn't the only goal of the law, and law and economics had as its basic goal efficiency and wealth maximization, but a little bit different from justice and following the rules laid down, I think. That's not to say, though, that a lot of, especially early law and economics, wasn't helpful in clearing away the detritus from some of the more horrifying things done by the Warren Court jurisprudence, I think.
Okay, you can put your hands up if you have a question. We'll come to you in a moment. I have a question myself, Stephen. I wonder if you've seen the latest list of potential Supreme Court nominees that the administration has put out. I noticed some of the names I don't follow as closely as you, obviously. Brett Kavanaugh was a name on there that I know has been kicked around for at least a decade for these sorts of things. And I noticed there were a few or at least non-judges at this point. Senator Mike Lee was on that list. I wonder if you could react a little bit to that new list, I think, of 25 people, and even the idea that, Well, the Supreme Court now, what is it? Everybody on the Supreme Court either went to Yale or Harvard Law School.
That's correct.
I don't think Mike Lee went to Harvard Law School. Maybe he did. But at least he lives in Utah, and he's been out there in the regular world. I wonder if you could talk a little bit about the idea that the Supreme Court, as the founders envisioned it, didn't necessarily mean everybody has to be a graduate of the elite law schools, but could be from a lesser law school, or maybe not even have all that much formal legal training to begin with. And I would think maybe Mike Lee would qualify as that.
Well, I think he probably would. It's pretty clear that the Constitution contains no requirements for Supreme Court justices, not even that they be lawyers, although I think all but maybe one or two have been. I guess, I mean, like you, I'm sympathetic to the notion of having folks maybe who didn't go to Harvard and Yale, but I'm very nervous about the idea of having the Supreme Court required to be a representative body. I think we moved in that direction. You know, we have to have a Hispanic, we have to have somebody who's black, we have to have 3 or 4 women. I don't think that really does much for the notion that justice is blind and the law is objective. But having said all that, I've only seen 4 or 5 of those names. One of them is Joan Larson, who's a Northwestern law grad and who I believe was my student. So I'd like to see her on the court.
She's on the top of the list then.
Yeah.
But what about the idea of somebody like a Mike Lee or somebody from outside of the usual system of appellate court judges rising to the Supreme Court? Do you think that'd be a good thing for the country, bring a different perspective?
I think it probably would. Here's something that Posner might have gotten right. Right before he retired, he said, you know, I believe this Supreme Court is the most mediocre in our history. An extraordinary thing for a Court of Appeals judge to say. But his reason for that was none of them has really had any real world experience that counts. And then he cited Jackson, who'd been a Nuremberg prosecutor and a lot of other interesting non-judicial activities. So from that perspective, Mike Lee would be marvelous.
We have a question back here.
Yep, Diane Bast. You had mentioned Neil Gorsuch and your expectation that he'll be a very good justice.
Yes.
Could you explain that a little bit more? Why?
He has indicated in some of the things that he's written that even though he clerked for Justice Kennedy, which might be disqualifying all by itself, but even though he clerked for Justice Kennedy, he indicated that Scalia was really his model jurisprud. And as you may know, when Scalia died, it's reported that Gorsuch actually shed real tears. And I think he meant them. Finally, unbeknownst to me, there was this curious, soft-spoken guy that I had dinner with when I gave a speech out in Colorado, who I was told was a 10th Circuit judge. It was Gorsuch, and he was terrific. As I say, they're very soft-spoken, very retiring. I wouldn't have known. I have full confidence in the guy.
We have another question right back here.
Wonderful evening. I'm Dan Hales, and I have a question about appointment of judges. Under the executive branch, the president has charged with the duty of interviewing, scanning, and appointing judges. Now the Senate, those little devils over there, through the blue slip process, are trying to game the system much like a bunch of school kids when one puts a book under the pinball machine. Tell us a little bit about the blue slip process, and it looks like it's being challenged now and may be ended.
Yeah, I think the blue slip process by which a senator could essentially blackball, to mix our colors, a judge from his own state isn't anything that's established in the law. I'm not even sure it's in the Senate rules. It's clearly not in the Constitution. And from what informal understanding I have about these things, and it's not much, yes, the president nominates, but there is a formal or an informal procedure that has local politicians funneling names to the president. And for a long time, there was an extraordinary amount of control that senators and even representatives had over the process. That certainly wasn't contemplated. And I think we're on the way to seeing that go. McConnell has hinted that he might simply start ignoring blue slips. We'll see if it happens. I think it'd be a great, great phenomenon.
We have another question right up front here, Mike.
You hear a lot of comments about how the academy is not receptive to any non-leftist ideas and don't allow, et cetera. What is your experience and your assessment of the state of play in law schools?
It is precisely that. Now, I'm being a little bit negative. I've been tolerated and not run out on a rail for 40 years. Tells you something about Northwestern. My ideas have been what they are now for a long time. On the other hand, I believe that one could literally count the number of Trump supporters on one hand. I think there were 5 of us. If you look at the statistics on donations to the political parties in the law school world, it is at least 85% Democrat, 15% Republican. To find more than 3 Republicans on any law school faculty is quite a feat. They do exist. Brigham Young, for example, might even have something close to a majority. Chicago, for a while, might have had 40%. Northwestern, maybe 15 to 20. That's unusual. On the other hand, Harvard has just picked a conservative to be its dean. So the tide may be turning. But I'm an incurable optimist.
Any more questions? Raise your hand. Another one here for Jan.
It's Selena Zito, a journalist, said, and she was absolutely right, that Trump's supporters take him literally but not seriously, while his supporters take him seriously but not literally. You got to think of him as speaking metaphorically, or it's not going to work.
And that's a great place to end it. How about a round of applause for our speaker tonight, Stephen Presser.
Thank you very much.
I'll just say that thank you all for being here. I really appreciate you coming out tonight and watching the live stream. And happy Thanksgiving to everybody. Thanks for coming out on Thanksgiving week. The next event here in this space is going to be on December 9th. I believe that is a Wednesday. The event is Helping Students Understand the Constitution, which is certainly necessary. I think it actually flows very well with Stephen Presser's presentation tonight. The speaker is going to be Nick Adams, who's a best-selling author and commentator on the Fox News Channel. It's going to be a very lively discussion, very informative, and something you can bring your kids to. So maybe we'll see you there with your family on December 9th. Thank you all for being here. Happy Thanksgiving, and we'll see you next time.